May it please the court, Christopher Kuhlman on behalf of the appellant Jonathon Ziesmer. On August 22nd, 2010, my client was driving on 94 eastbound with two passengers in his car. A lit cigarette landed in the back seat. My client pulled over to the side of the road so it could be put out. And while the cigarette was being put out, a state trooper pulled up beside them, State Trooper Hagen, to see what was going on. He approached the car. He talked to all the passengers in the car, asked them why they were pulled over. They explained why. He then asked them for their identification, and he turned his back on them and walked slowly back to his squad car and ran all of their IDs in the state trooper's database. Nothing was found, no outstanding warrants, all law-abiding citizens. He comes back to the car, and this time he orders one of the passengers outside of the car. The passenger complies, but as he's getting out of the car, state trooper unnecessarily shoves him into the car. This scares my client. It scares the other passenger in the car. My client is concerned about what's going on. The trooper searches the first passenger taken out of the car. He then approaches my client, asks him to get out of the car, and my client asks a question: why do I need to get out of the car? Please explain what's going on. The trooper refuses to answer. He starts raising his voice. My client, upon seeing what he did to his friend, starts to question this trooper's professionalism. He's scared. He actually calls 911 on the trooper. The trooper sees this, grabs the phone, throws it in the car, yanks my client out of the car, brings him back beside the car, and then there's a brief moment for about 30 seconds to a minute where my client's standing there. The trooper tackles him. He then places him in handcuffs. He's clearly in handcuffs in his stomach, and he punches him 6 to 8 times on the back of the head. My client has brought a 1983 claim against Trooper Hagen for this conduct. It's clearly not allowed under the Constitution. At the lower court, the analysis came down to Chambers. And so we didn't even need to get into the facts of the case because the judge correctly picked upon Chambers and was adequately briefed at the district court, which said that prior to, I believe it was 2010, a trooper or a police officer under the color of state law could inflict injury upon a civilian and not face any civil liability as long as the injury is de minimis.
I do have one question about what's before us. In the district court, in one of the footnotes, the court said there's no dispute that the trooper was justified in demanding Ziesmer exit the car or in effecting Ziesmer's brief detention. Is that true? Is that not before this court or before the district court?
Well, appellant, we addressed that in sort of the second part of our brief, but I actually do dispute that. I don't dispute that the trooper had a right. He did have a right to come up and see what was going on. He had a right to make an investigatory stop and see what was going on. But at some point, if there's no probable cause, his search has to stop. And I submitted to the district court and I submit to this panel that the moment he ran those identifications, found out that there was no outstanding warrants, there was no signs of any crime whatsoever, the search should have stopped, and he had no reason to order my client out of the car.
Did you plead that sort of a claim, or was it pled as an excessive force claim?
It was pled as an unreasonable search and seizure and excessive force claim. I won't dispute that the focus was an excessive force claim. That was our front and center claim. But I believe under the Fourth Amendment, this is also an unreasonable search and seizure, and excessive force is a component of an unreasonable search and seizure claim. So the issue before the court is today, I believe, is quite a simple one, and I think it was made quite more simpler by the United States Supreme Court in Tolan, which ruled, I think, just 3 or 4 days before the district court issued this opinion. And the issue is whether my client suffered a de minimis injury, and we believe there's sufficient evidence on the record that was submitted to the district court for a jury to conclude that he suffered more than a de minimis injury. The evidence is twofold. It comes through his testimony in that he had an immediate onset of the injury right afterwards and felt pain. And it comes through his actions of going to see treating doctors to keep remedying his pain for a scope of 3 years after this. He's seen about 34 doctors and physical therapists. And that establishes more than a diminished injury. And maybe it doesn't establish, but that's for the jury to decide, and I think that's the issue.
Can we break it down a little bit? Let's, if I recall right, there were maybe some scratches and bruising, that sort of thing. Would you agree that that's probably de minimis?
I would agree that the scratching and the bruising is de minimis. I'm not going to make that argument.
Then we've got neck and shoulder.
Correct.
Shoulder, as I understand, maybe he didn't even seek treatment until 2013 for the shoulder?
Well, the respondent was very clever in their brief, and they isolated the specific areas where my client received treatment. Here's what happened. My client, 5 days after the incident, like any normal citizen, he didn't need to go to the hospital right away. He waited to see if he'd get better. He waited 5 days. He got an x-ray. And then, I believe it's laid out in our reply brief, but there's a chart of everything that happens. He's having pain in the same generalized region, whether it's his shoulder, his neck. It's not uncommon to go to many different doctors and to be referred to someone else. I'm not seeing anything wrong with your neck. If he comes in complaining of his neck, this is all very related. This is interrelated area. And so, yes, no one diagnoses his shoulder for 3 years later, but he receives treatment on August 27th, 5 days after the incident, for his back pain, neck pain. That's what he presents with issues. 3 months later, they give him some exercises. They take a wait-and-see approach. He gets a spine on his MRI of his neck pain and upper back, which I think would constitute shoulder. Months later, he goes to see, or just a week later, he goes to see a doctor. But I would point to the reply brief. We don't need to go through all of this, but there is a continual follow-up. He's continuing to seek treatment. He's continuing to experience pain, and the doctors are referring him to different specialists to try and manage this pain.
Let me add, factually, is it true that he was never diagnosed with a particular neck or shoulder issue, bulging disc, that sort of thing, a specific diagnosis?
He has been diagnosed with minimal disc bulging, and
it's kind of characterized as incidental or something like that.
That's what the doctor said. It can be incidental. They don't know. This is something that can come up through a lifetime, or it can come through an injury.
Let me ask you, does it in the context of trying to determine whether it's above the level of de minimis, does it matter whether a diagnosis was made?
I don't believe so, Your Honor, because I believe this is within the province of a jury. A jury understands these issues. We all have old injuries from youth sports. Most jurors have all been in car accidents before, and they can understand that an immediate onset after a sudden jarring impact can cause an injury. And I think we should be looking not so much at pinpointing exact diagnosis, but more so on the continuing treatment and the continuing pain that lingers thereafter. A diagnosis is hard in the medical community. We like to believe it's an exact science, but it's not uncommon when you present to your doctor with symptoms that there's much follow-up done, that you're referred to other specialists until they figure out what's going on and how to treat and manage this pain.
What about connecting the pain, the ongoing problem, to the initial incident with the trooper? This is sort of one of those drawn-out injuries, right? That I think that's what your point is, right? That it's ongoing, doesn't necessarily result in a broken bone immediately, but results in kind of a long-term injury. What do we need an expert to connect that up so that a jury could see that, or is it your view that your client's testimony is enough?
I think that's an evidence-weighing consideration for the jury to consider. Certainly, yes, an expert could connect that up. That's a way to present it to a jury, but his testimony under the law of the Eighth Circuit and in Minnesota is enough if a jury can understand this injury. You don't need an expert to connect this up. And I would point you in the brief to the Turner v. Iowa case by this Eighth Circuit that says an immediate causal connection between an event and an injury may be inferred in cases in which a visible injury or a sudden onset of an injury occurs. You don't need an expert if the onset is immediate, and my client's testimony established that. He's never had neck or back pain before this. He's never gone to these doctors presenting neck or back pain. This isn't an old injury that is re-aggravated. This is something for 20 years of his life. He's never had a single complaint with his neck or back until he's in handcuffs and he's punched with enough force to drive his head into the ground 6 to 8 times. So no, you don't need an expert witness. That's certainly a litigation strategy we could have employed, but it's not necessary here. That's our contention. Finally, there's a second argument advanced in our brief that looks at Chambers. It's the second portion, and there's actually, I don't know if it's fair to call it a circuit split, but in the United States District Court, District of Minnesota, there's a group of judges that have gone 2 different ways on these pre-Chambers decisions. 2 of those judges are Schultz and Judge Erickson, who have said if there's no reason to have a search and the search should not be done, no one should be subjected to any force whatsoever, and so Chambers doesn't even matter. And as was pointed out by the respondent in their brief, Judge Kyle has gone the other way in the United States District of Minnesota, and he has said that's not the case, and the decision he cites is the Robinson v. City of Minneapolis. So there's a divergence here between the 2 courts. I would say that the appellant says that this is like Chambers, and that Chambers applies, but I think the facts are a little different. They're saying that because the officers in Chambers had no right to use any force or seize the person, that the de minimis injury should be maintained by the court. Chambers is different because there was a search warrant in Chambers. So the police actually had cause to search the house and the persons in the house, and they had a right to search the individual in Chambers. Here there was no search warrant. This was an investigatory stop that went too far, and because it went too far, my client should have been subjected to any force whatsoever. So as an alternative theory, Chambers does not apply under those circumstances. I'll reserve the rest of my time for rebuttal unless there's more questions.
Good morning, Your Honors. My name is Michael Goodwin. I'm an Assistant Attorney General for the Minnesota Attorney General's Office, and I represent the appellee in this action, Trooper Derick Hagen. This court should affirm the district court because the plaintiff's injuries are de minimis as a matter of law, and because the undisputed facts in the record do not, as a matter of law, establish that the injuries are more than de minimis, or that there is a causal connection between the alleged use of force and the plaintiff's claimed injuries. This incident occurred well before the court clarified the law in Chambers. As the court has recognized numerous times, the law prior to Chambers was uncertain as to de minimis injuries. Because the law was uncertain at the time of this incident, Trooper Hagen is entitled to qualified immunity, and therefore summary judgment was properly granted. Your Honors, to address one of the questions that the court had, this case is and always has been an excessive force and an excessive force only claim. It is pled as a 1-count excessive force claim. That is the only issue that is before the court.
So your view is that that footnote by the district court is accurate, that there's no dispute as to whether the trooper properly seized him at the time he took him out of the car?
That's correct, Your Honor, and the court noted that the appellant was non-compliant with the trooper's command. That in and of itself gives the trooper a basis under this court's case law to use some degree of force in taking the suspect, in seizing the suspect. So to answer your question, Your Honor, that footnote is correct. That footnote is accurate.
Okay, so on the neck and shoulder,
Mm-hmm.
there's a whole litany of evidence of him, within months, going to his primary care physician, going to specialists, getting MRIs and CT scans, and complaining about pain. Why doesn't that get us beyond a de minimis injury, especially when you add to it that he testified didn't have any problems before and they started shortly thereafter?
Sure, Your Honor. First, Your Honor, this court's case law indicates that a diagnosis is in fact necessary. In the Copeland,
What case says that?
The Copeland case says that more than mere pain. I'm quoting more than mere pain. The plaintiff had more than mere pain, and therefore could establish that he had more than a de minimis injury. More importantly, Your Honor, the plaintiff's own testimony is irrelevant and was properly disregarded by the district court in this case because the plaintiff himself, in his deposition, testified that he is not competent to diagnose his own injuries. This is page 122 of the appendix. Therefore, the plaintiff's own testimony as to his injuries does not create a fact issue.
Who better, though, to describe the experience of pain, discomfort, why you're going to the doctor or the chiropractor or the physical therapist than the person himself?
But, Your Honor, to support an excessive force claim, it requires more than mere pain. All he's alleged in his interrogatories in his deposition is pain. That in and of itself is not enough to create a fact issue as to whether the injury was de minimis or not. Nowhere in the hundreds of pages of medical records, in the months of treatment, does anyone make a diagnosis as to the source of his pain. And certainly nowhere in those medical records does any of the treating physicians, any of the therapists, any of the nurses, no one makes any finding as to causation. As the court pointed out, the neck pain was regarded by one of the physicians that was disclosed as an incidental finding. That means that it could have been caused by anything. It could have been just a degenerative condition that was exacerbated.
What about the evidence, though, that a sudden onset, having had no problems before, isn't that enough that a jury ought to be able to look at it?
No, Your Honor, and this court's case law forecloses that argument. In Brooks, the court rejected the same argument. In that case, the plaintiff said that he did not have pain prior to going beneath the locomotive, and when he came out, he did. It was the same sudden onset argument that was made in this case, that's being made in this case, and the court should reject it for the same reasons. The court also rejected a similar argument in Lash versus Hollis, which was an excessive force claim in which the plaintiff claimed kidney disease from a taser. The plaintiff said that he'd never had problems with his kidneys prior to that, and the court rejected the sudden onset argument that plaintiff is making here in that case. In Turner itself, the case that plaintiff cites for the sudden onset doctrine, the court said that an injury that is sophisticated is something that requires a complex medical diagnosis. Here, the very fact that plaintiff has gone to multiple physicians over the course of several years and none of them have been able to tell him either what is wrong or what caused it, that in and of itself is evidence that this is a complex medical condition, potentially with multiple causes, not necessarily related to anything that the trooper did.
In that scenario, though, if your setup is multiple providers simply are stumped, they don't know what happened, how would a plaintiff ever get an expert to actually testify as to the link if they've already tried and no one can?
It's still the plaintiff's burden, Your Honor, to establish causation between the injury and the allegedly unconstitutional conduct. If no expert can establish that causal link, then the plaintiff's claim fails. Whether the plaintiff has tried and gone to one expert, two experts, three experts, a dozen experts, if none of the individuals that plaintiff puts forth to support their claim, none of the professionals, even if they had been properly disclosed as experts, if none of them can support that causal link, Your Honor, the plaintiff's claim fails as a matter of law.
What about Robinson that says that a causal connection between an event and an injury may be inferred in cases in which a visible injury or a sudden onset of injury occurs?
Well, those are two different things, Your Honor. A visible injury is one thing. Here there is no visible injury.
But we've got evidence of sudden onset.
But under this court's sudden onset case law, there has to be more than just pain. It has to be an actual injury. There's no case that I'm aware of in the circuit in which a sudden onset of mere pain has supported an injury. And I think, Your Honor, a fair reading of Brooks is that that is insufficient. As to the argument regarding gratuitous force, Chambers itself forecloses that argument, Your Honors. In Chambers itself, the court specifically identified the force used as gratuitous, and it still wasn't enough, even though the plaintiff, at the time the force was applied that allegedly caused the plaintiff's injuries, the plaintiff was in handcuffs. The plaintiff, in fact, for part of that period of time was secured in a police car and alleged that the officer was kicking the back of his chair. The gratuitous use of force argument is foreclosed by Chambers itself, as well as by Andrews, where the court said that even if the force used was unnecessary, a de minimis injury precludes an excessive force claim. The intra-circuit split that the plaintiff pointed out, Your Honor, is itself indicative of the propriety of qualified immunity. If the case law isn't clear, if the case law doesn't tell the officer what's constitutional and what's not, the officer is entitled to qualified immunity. The fact that judges in this circuit disagree over that very question itself entitles the trooper to qualified immunity. And briefly, Your Honor, as to the Tolan case that was decided by the U.S. Supreme Court, that case has no application to these facts. In Tolan, the reason the Supreme Court reversed was because there were witnesses testifying as to contrary liability facts, and the court disregarded those witnesses' testimonies. Here we have a witness who has admitted that he is not competent to testify about what he purports to use to support his claim. That was not the case in Tolan. Tolan has no application to these facts. To conclude, Your Honors, the plaintiff simply did not substantiate his claims with the district court. Summary judgment was properly granted, and the respondent asked that this court affirm the district court's grant of qualified immunity. And unless there are no further questions, I'll sit down.
Very well. Thank you, Mr. Goodwin.
Thank you, Your Honors.
Mr. Coleman, while you're coming up, you heard me ask a couple questions about the requirement of a diagnosis and that sort of thing, and Mr. Goodwin cited back to me Brooks and Copeland. Is he right about that?
He is flat out wrong about Brooks. And I understand he's not the attorney that wrote the brief, but Brooks is an entirely different case, and I spent considerable time distinguishing it in my brief, but the facts in Brooks are as follows. An employee goes to work. By the end of the day, he leaves work and he notices he's in pain. What caused the pain, I don't know. I just know that it's something during the day. I showed up with pain. There's not something that falls on him. There's not something that strikes him that he points to right away. Brooks is not comparable here. So this is an immediate onset. He knew right after that first punch hit him in the head, or maybe 2 seconds afterwards, immediate onset of pain. He knew what caused the pain. Brooks doesn't know what caused the pain, and that's why that case is very distinguishable. Yes, my client's not a doctor. He can't diagnose. He's not a medical doctor. He can't diagnose treatment, But what Tolan explained to the Fifth Circuit was that his testimony about what he experienced and what he felt still needs to be credited and still needs to be heard. And that's something for a jury to decide. So he can still get on the stand and testify how the immediate onset of pain, how it's affected him, how it's changed his day-to-day life. He doesn't need a diagnosis. The fact that he's still trying to treat this pain and trying to find pain management remedies in itself should be enough and makes it more than a de minimis injury. Thank you.
Very well, counsel. We appreciate your arguments today. Case will be submitted and decided in due course.